The land had always been quiet. Not the kind of quiet that feels empty, but the kind that feels owned, earned through years of work, patience, and paperwork most people never bothered to read. I bought the property long before the neighborhood around it even existed. Back then, it was just dirt roads, open sky, and a promise I made to myself that no one would ever tell me what I could or couldn't do on my own land. Years passed. Development crept in slowly at first, then all at once. A homeowners association formed nearby, filled with identical houses, matching mailboxes, and people who believed rules mattered more than reality. I stayed outside their boundaries, legally, clearly, permanently. Or so I thought. At first, the HOA barely noticed me. I wasn't part of their meetings, didn't attend their events, didn't answer their letters. I assumed that would be the end of it. But HOAs don't work that way. Silence doesn't mean respect to them, it means opportunity. One morning, I noticed survey flags near the edge of my property. Bright colors stuck into the soil where they had no business being. I assumed it was a mistake. Surveyors make them all the time, and reasonable people fix reasonable errors. I removed the flags and moved on. A week later, more appeared. This time, they went deeper. The flags formed a straight line that cut directly through land I had owned for years. That was when I knew it wasn't a mistake anymore. Someone had drawn new boundaries without asking permission. Soon after, letters started arriving. Official-looking envelopes filled with vague language and confident assumptions. The HOA claimed there was a discrepancy in property lines. They spoke about easements, access paths, and future development plans. The tone was polite on the surface, but underneath it carried something darker, certainty. They believed they were right. I didn't respond immediately. Instead, I pulled out my original deed, survey maps, and county records. Everything was clear. My land was my land. No shared access. No easements. No HOA authority. I had documentation older than their entire organization. Still, I felt uneasy. HOAs don't bluff unless they think they can win. Then the machines arrived. I wasn't home when it happened. Neighbors later told me the sound echoed across the area, heavy engines, metal tracks, the unmistakable growl of construction equipment. Bulldozers rolled in like they belonged there, followed by workers who didn't ask questions. They never do. By the time I arrived, the damage was already done. A wide strip of my property had been flattened. Trees I had planted years ago were gone. Fencing was crushed. The ground was torn open like someone had peeled back my rights with steel blades. They weren't just trespassing, they were reshaping my land. All of it was happening under the assumption that resistance didn't exist. The HOA later claimed it was part of an approved development expansion. They said the land was included in updated community plans. They said the paperwork was being finalized. They said a lot of things people say when they think momentum will protect them. What they didn't expect was documentation. What they didn't expect was patience. Most people would panic. Some would shout. Others would hire a lawyer immediately and drain themselves emotionally and financially in the process. I did none of that. I documented everything: photos, timestamps, equipment serial numbers, company logos. I collected names without confrontation. I let them keep working. Because every minute those bulldozers moved, they made my case stronger. The HOA sent another letter soon after, this one firmer, more aggressive. It referenced municipal cooperation and implied legal backing. It suggested compliance would be easier than resistance. They framed destruction as progress. But progress without permission is still a crime. What the HOA didn't realize was that they had stepped into a legal maze built entirely out of their own arrogance. Zoning laws. Property rights. Environmental regulations. Historical land use clauses. Local ordinances most people never read, but I had. I didn't stop them yet. Instead, I made calls. Quiet ones. County offices. Environmental departments. Records divisions. I asked questions that sounded innocent but carried weight. Each answer confirmed what I already suspected: the HOA had no authority here. None. They weren't just wrong. They were exposed. The bulldozers eventually left, satisfied with the damage done. The HOA likely believed resistance had ended before it even started. They assumed silence meant surrender. That assumption would cost them everything. As the dust settled, I stood on the edge of my land, looking at what they had destroyed. Not with anger, but with clarity. Every flattened tree, every torn fence, every inch of disturbed soil had become evidence. Evidence that couldn't be undone. The HOA thought bulldozers meant power. I knew they meant liability. And I was just getting started. After the bulldozers left, the HOA believed the situation was settled. In their minds, land had been claimed, boundaries had been redrawn, and resistance had been crushed before it could even form. They returned to their meetings, their spreadsheets, and their carefully planned expansion timelines, unaware that every decision they had made was now stacked neatly against them. I stayed quiet on purpose. Silence made them bold. And boldness makes people careless. While they celebrated progress, I built a record. I gathered county plats going back decades, including surveys stamped and approved long before the HOA existed. I pulled zoning maps that clearly marked my property as independent and unrestricted. I reviewed environmental protection rules they had violated the moment their machines tore into protected soil. What they saw as development, the law saw as unauthorized destruction. The deeper I looked, the worse it became for them. The bulldozers hadn't just crossed property lines. They had crossed jurisdictional ones too. Parts of my land fell under environmental oversight due to drainage patterns and native vegetation. The HOA never requested permits. The contractors never verified ownership. Everyone assumed someone else had checked. No one had. Instead of confronting the HOA directly, I filed reports. Not emotional complaints, formal notices backed by documentation. Each agency received only the information relevant to them. County zoning received boundary violations. Environmental offices received land disturbance reports. Permit departments received evidence of unapproved construction activity. Each report triggered its own process. Within weeks, the HOA began receiving letters that looked nothing like the ones they had sent me. These weren't polite suggestions or vague warnings. These were official inquiries, deadlines, and notices of investigation. Suddenly, the confidence in their communications disappeared. Meetings grew tense. Lawyers were consulted. Contractors were asked questions they didn't like answering. The HOA tried to control the situation by doing what they always did, pushing harder. They sent another notice claiming shared access rights, citing internal maps and amended plans. But internal maps don't override county records. And amended plans don't rewrite history. That letter became another piece of evidence. Soon, inspectors arrived. Not just one, several. They walked the damaged land, measured disturbed areas, photographed equipment tracks, and marked zones with colored tape. Every marker told the same story: unauthorized activity. The HOA attempted to shift blame onto the contractors. The contractors pointed back at the HOA. Responsibility bounced between them like a hot object no one wanted to hold. But legally, it didn't matter. Authorization begins at the top. And the HOA had authorized everything. Fines were discussed. Restoration orders were mentioned. Stop work notices were issued, not just for my land, but for adjacent projects connected to the same development phase. Suddenly, their expansion stalled. That's when they realized the problem wasn't just land anymore. It was exposure. The HOA's legal team finally reached out, not with threats, but with questions. They wanted to clarify misunderstandings. They asked for meetings. They suggested cooperation. The tone had changed completely. I still didn't rush. I let the process continue on its own momentum. Agencies don't like interference, and they don't like being rushed. The more time passed, the more the situation expanded beyond anyone's control. What started as a land grab was now a multi-department review. Neighbors began to notice. Construction delays. Equipment sitting idle. Rumors spread fast in HOA communities, and fear spreads faster. Board members started blaming each other. Votes were questioned. Decisions were second-guessed. And then the restoration order came. The HOA was instructed to submit a full environmental recovery plan. For the damaged area, my land. That meant assessments, timelines, costs, and long-term monitoring. They were required to return the land to its previous condition or face escalating penalties. Restoration wasn't cheap. And it wasn't optional. But there was more. Because of how the HOA handled internal approvals, their actions triggered a review of their governing authority. County officials questioned whether the HOA had exceeded its charter. That review opened doors the HOA never wanted opened. Suddenly, years of aggressive enforcement practices came under scrutiny. I didn't push this part. I didn't need to. Once the door was open, others stepped forward, homeowners who had been fined unfairly, restricted without cause, pressured into compliance through threats instead of law. My case had created an opportunity. The HOA's power structure began to crack. They attempted to negotiate quietly, proposing compensation and boundary agreements. But at this stage, negotiation wasn't about money anymore. It was about accountability. The damage they caused couldn't be erased with a check. They wanted resolution. I wanted consequences. By the end of the chapter, the HOA was no longer expanding. They were defending. Legal fees piled up. Board meetings became emergency sessions. Their reputation suffered. And every move they made was now watched by multiple agencies. They had tried to take land with bulldozers. They ended up buried under paperwork. And they still had no idea how much worse it was about to get. By the time the HOA understood the full scale of the situation, control was already gone. What they once managed through authority and intimidation was now dictated by deadlines, compliance orders, and legal oversight. Every move they made required approval. Every decision carried consequences. The system they relied on had turned against them. The environmental restoration plan became their first major burden. What sounded simple on paper turned into a financial nightmare. Specialists were required to assess soil damage, water flow disruption, and long-term ecological impact. The land had to be restored not just visually, but functionally. Trees had to be replaced with approved species. Drainage patterns had to be corrected. Monitoring reports had to be submitted for years. All of it paid for by the HOA. As costs mounted, homeowners began asking questions. Dues increased. Projects were delayed. Promised amenities were quietly removed from future plans. What once felt like a powerful organization now felt like a sinking ship, weighed down by mistakes no one wanted to claim responsibility for. The county's review of the HOA's authority moved faster than expected. Investigators examined how decisions were approved, how boundaries were defined, and how enforcement actions were carried out. Patterns emerged. Overreach wasn't accidental, it was routine. The bulldozers hadn't been a one-time error. They were the result of years of unchecked behavior. That realization changed everything. Restrictions the HOA had enforced aggressively were suddenly suspended. Pending violations were paused. Homeowners who had been fined or threatened found their cases reopened. The board's credibility eroded with every new finding. Then came the legal ruling that sealed their fate. stopped them from touching my land again. It stripped them of any claim they had tried to manufacture. But the consequences didn't end there. Because of how the HOA funded the illegal work, insurance providers refused coverage. Contractors distanced themselves. Legal counsel advised damage control rather than defense. The HOA was now exposed on multiple fronts, and there was no way to isolate the fallout. A court-ordered settlement followed. Not one negotiated in private, but one documented publicly. The HOA was required to pay for full restoration, cover regulatory penalties, and compensate for property damage. More importantly, they were barred from any future development activity near my land without independent approval. Their expansion plans were permanently cancelled. The board changed after that. Resignations followed quietly. New members inherited a structure weakened by mistrust and debt. The HOA still existed on paper, but its influence was gone. What once controlled through fear now struggled to function at all. As for my land, it was restored slowly and carefully. The damage faded, replaced by new growth and corrected boundaries. Permanent markers were installed, clearly defining ownership in a way no one could challenge again. My property records were updated, reinforced, and locked beyond dispute. I didn't need revenge. The law handled everything. The bulldozers that once symbolized power became evidence of failure. The letters that tried to intimidate me were archived as proof. The silence I chose in the beginning became the loudest statement in the end. The HOA thought rules were weapons. They forgot rules are limits. They believed authority came from confidence. They learned authority comes from legality. And in trying to take something that was never theirs, they exposed everything they were doing wrong. The land remained mine. The HOA paid the price. And the lesson was permanent.